All right, good afternoon, everyone. My name is Kawolo Kame. I'm an attorney with the Meriden Legal Aid. I'm part of the Community Lawyering Initiative, and I'm uh, grateful and I thank you guys for having me today and to give this presentation about Know Your Rights during COVID-19. A little bit about me, like I said, Mr. Attorney Meriden Legal Aid. This is my email address and my phone number that you're currently seeing on the screen. Uh, Yes, as a disclaimer, the information provided in this presentation is current as of yesterday. Local laws and rules are changing regularly, so you want to keep an eye out for new changes. And if you have, I'm going to take general questions at the end of this presentation, but if you have uh, questions specific to you or you need a more detailed answer, please feel free to contact me at either email or phone number. Again, my email address is on the screen. My phone number is 443-951-7762. So today we will be covering the following topics. I'm going to give you code updates. I'm going to talk about tenant rights. I'm going to talk about family law. I'm going to talk about emergency sick leave, unemployment insurance. I'm also going to talk briefly about foreclosure, student loan, and debt collections. And I'm going to talk about expungement. So prior to COVID, expungement was sort of our day job, so to speak. So I'm just going to talk a little bit about that at the end of this. Beginning with code updates, protective order petitions, peace order petitions, extreme risk protective order petitions, generally known as restraining orders, are now handled by commissioners. Under normal circumstances, if you wanted to file any of these, you had to file it with the clerk's office. Or for information about your local district commissioner's office, you can either just Google, district commissioner's office in your county, or you can go on this website that is now showing on the screen. Or the reopening schedule may be different from county to county, so you want to call your clerk's office if you're not sure. But generally, for the state of Maryland, there are 5 phases in total. It's important to keep in mind that any person entering court is subject to COVID-19 screening questions or non-contact temperature checks if available. You will be required to wear face mask and face covering. You're also required to maintain social distance. If for whatever reason you refuse to comply with these restrictions, you will be asked to leave. So these are the phases. So we've already completed the first 2 phases. So phase 1 was from May 4th to June 5th. During that period, the courts heard only emergency matters. So criminal, civil, juvenile matters that were limited to addressing immediate danger or persons in custody. Examples include, but not limited to, shelter care hearing, juvenile detention hearing, body attachment hearing, extreme risk protective order hearing. And some of these are legally, some of these might be common. So if you have questions about specific things I'm addressing, please feel free to ask me at the end. Phase 2 was from June 5th to July 19th. During that time, the Court of Appeals and the Special Appeals became fully operational. Circuit and district courts started hearing status conferences, scheduling conferences, and matters that could be handled remotely or without testimony, or both. Juvenile, criminal, and senile, that's children in need of assistance matters that required no testimony or allowed remote testimony resumed. For landlord-tenant issues, emergency breach of lease involving threats or injury to people or property were heard during that time. Also, emergency wrongful detainer actions were heard. Problem-solving courts resumed. Again, more hearings resumed remotely and on-site. The clerk office was closed to the public during that period. Phase 3, which is the phase we are currently in, that's from July 20th to August 30th. More hearings are allowed. Non-expungement hearings that involve witness testimony have resumed. Non-emergency hearing, that involve witness testimony have resumed. Expungements, violations of probation, motions, contested termination of parental rights, and non-jury trials have started. If you were previously sentenced prior to the lockdown, that sentence will now take effect. Also, for landlord-tenant cases, rent escrow actions have resumed, tenant holding over actions have resumed, and warrants of restitution have resumed. So just a little explanation, rent escrow is if there are conditions to your property that threaten your health and safety, you can now file those actions. Tenant holding over, as the name implies, if your lease ended and you're still in the property. Warrants of restitution is what you take to the sheriff's office if you're a landlord to have a tenant evicted, and I'll go more into that later. The clerk's office is now open to the public. From August 31st to October 4th, that will be considered phase 4. Now keep in mind, this is all contingent on the COVID-19 situation continuing to improve. These are all subject to change if things get worse. So from August 31st to October 4th, non-jury trials in criminal, civil, family, and juvenile matters will resume. Family law hearings and trials will start. Child support contempt hearing will start. Most non-jury courts will become fully operational. There will still be a limit on concentration of individuals, and we will still be encouraged to practice social distancing. And phase 5 begins October 5th. So that's when courts become fully operational, including jury trials. So basically everything is back to normal. Again, there will still be a limit on concentration of individuals, and social distancing will be encouraged as directed by the CDC and MDH. Sorry, there was someone coming to my office. Tenant rights. You have to pay your rent. There was an eviction stay that was lifted on July 25th. So I think most people might have heard about that. There was a stay put in place, but that was lifted on July 25th. Eviction stay for federally funded housing will be lifted on August 31st. We have no information to suggest that there will be a new eviction stay issued. Now, obviously, there have been some communications to extend this stay, or at least to reenact the stay, but I have no information currently to tell you that this stay will be reinstated. Landlords who are filing for a failure to pay rent action have to fill out a declaration of compliance if they file between March 27th and July 25th. And if they are filing after the failure to pay rent, again, because the stay is lifted, the eviction is not stayed. Now, this is important to understand. So even though the stay has been lifted, courts cannot issue a judgment of possession. That is basically, you can be evicted if you can show a loss of income due to COVID-19 or the state of emergency. Now, there's no specifics as far as what you must provide to show, but there must be documentation. So, for instance, maybe if you have a letter from the employer stating that you lost your job or you were being laid off because of COVID-19, that's an example of a documentation that will be needed. Or again, it's not clear how much evidence you will need, but they must be objectively verifiable, or for a judge to decide that your loss of income was due to COVID-19 or the state of emergency. So if there were pending cases before March 27th, those cases will be set for trial on or after August 31st, 2020. And then again, like I said, from August 31st to October 4th, all other types of landlord-tenant cases, including failure to pay rent, will begin. For utilities, no gas, electric, sewage disposer, or telephone, water, cable, or internet provider can terminate your service until August 1st, 2020. So that's a couple of days from now. Also, And this started in March. So between March and August 1st, you couldn't have had your utilities turned off, and you couldn't be charged a late fee. Again, I'm not sure if this will be extended. Hopefully it is, but I have no information, as of now that this will be extended. Family law issue, and now we move on family law. So custody and visitation. So all court orders still apply. If order permits and both parents agree, custody time can be adjusted. If parents cannot both agree, then both parties must follow the order. Be courteous and use common sense. Child support. No change, no exception. You must still pay child support. Emergency sick leave. So who's eligible for emergency sick leave? So if you're a full-time or a part-time employee, if you are a private sector employer with fewer than 500 employees, or your employees are eligible. If you're an employer with fewer than 50 employees, or you might be exempt at Department of Labor discretion. Or you also must have a COVID-19 related reason. I'm going to talk about that next. And employees who have been employed for at least 30 days prior to their leave request may be eligible for an additional 10 weeks. So during this time, this state of emergency, which is still ongoing, employees may take up to 80 hours of emergency paid sick time. Excuse me. And for you to qualify, these are the COVID-19 related reasons that I mentioned briefly in the last slide. You have to be subject to a government quarantine or isolation order related to COVID-19. Or you must have been advised by a healthcare provider to self-quarantine due to COVID-19 related concerns. You must be experiencing symptoms of COVID-19 and seeking medical diagnosis. Or you need to take care of an individual who is experiencing one of the two conditions, or under 1 and 2. Also, if you need to take care of a child whose school or place of care is closed, or whose child care provider is unavailable due to COVID-19, or if you're experiencing any substantially similar condition. I'll leave this on for a few more seconds since I went through this fast for those who are reading along to see this. All right. Now, how much do you get paid? So again, these are a lot of numbers, so I'm just going to go through this quickly. But again, if you have specific questions about this, or contact me, I can go into more details. So if you are taking a paid sick leave because of you were subject to a quarantine order, or you were advised by a healthcare provider, or you are experiencing symptoms of seeking medical or diagnosis, you get paid 100%, or up to $511 daily and $5,110 in total. If you are taking a paid sick leave because you need to take care of an individual, or you're experiencing a substantially similar condition as one of these other things, you get paid 2/3 of your wages, up to $200 daily and $2,000 in total. And if you are taking a paid sick leave to take care of a child, or you get up to 12 weeks of paid sick leave and expanded family and medical leave paid at 2/3 for up to $200 daily and $12,000 in total. Again, like I said, these are a lot of numbers. Just to give you a general idea, but specifically, you can give me a call. Or more importantly, if you requested emergency paid sick leave and you were denied, even though you qualify, you can file a complaint with the U.S. Department of Labor, and this is their contact information. And for those who are listening, it's 1-866-487-9243. All right, so unemployment insurance, who can file? You must be a part-time or a full-time worker. People who you must have lost your job through no fault of your own. Now, under the COVID guidelines, you must be laid off because of loss of business or production tied to COVID-19, or you suffer reduced hours due to COVID-19. Usually, those who cannot file were those who couldn't work because they were sick, or those who had to take care of someone who is sick, and contractors and gig workers like Uber drivers, Lyft drivers, those are considered gig workers. Now, the changes that were made subject to COVID are that contractors, gig workers, and people who have to leave their jobs to avoid coronavirus exposure or to care for an affected family member may apply. Doctor or government issued notices will be required. People who are not eligible for marital unemployment insurance might be eligible for federal pandemic unemployment insurance under the new federal law. I won't go into details since I'm speaking mostly about marital law today, but if you have questions about the federal unemployment insurance, you can contact me for that as well. Now, how much do you get paid? About half of your gross weekly wages, which is up to $430 a week. Your earnings are calculated based over the first four of the last 5 calendar quarters. So, in other words, your last year earned in 2019. Now, under COVID, you would receive an additional $600 a week. Unfortunately, this ends on the 31st of this month, so in 2 days' time. Congress has been, trying to pass new legislation to extend this. It hasn't passed yet. I don't know when it will be passed or if it will be passed, and I don't know if the amounts will remain the same. So keep an eye out on that. But if you're receiving a $600 extra, you probably have already received your last $600 unless the new legislation is passed. How long will the benefits last? Normally, unemployment insurance in Maryland is 26 weeks. Due to COVID, you can qualify for an additional 13 weeks, and this is effective until December 31st, 2020. What you're required to do when you apply for unemployment insurance. So generally, people who are receiving unemployment benefits have to search for jobs. However, due to COVID, you are not required to search for jobs. Obviously, it's encouraged that you do, but you're not required to do it. But you may be required to log other employment activities, such as creating resumes and other things that they deem fit. How to apply? You can just Google Maryland Unemployment Insurance application. This is a website. You can do that. You can also apply by phone. If you are calling, and their office hours are 7:30 to 3:30 p.m. Monday through Fridays. If you are calling within the Baltimore metro area and from out of state, the number to call is 410-949-0022. If you're calling from other places within Maryland, the number is 800-827-4839. I'll talk briefly about foreclosure. So similar to landlord-tenant evictions, foreclosure proceedings related to residential properties were stayed until July 25th. If a mortgagee or a landlord was following the foreclosure action, they had to file a certification, in compliance with the CARES Act. I won't go into details of what that means, but just if you are a landlord or mortgagee, it's something to keep in mind. Mortgage relief may be available from the Federal Housing Finance Agency, or you may be eligible if you and or your spouse can no longer afford the mortgage payments on your home because of a reduced income, or if you're a landlord who is unable to collect rent from your residential tenants, and due to this, you can no longer afford your mortgage payment, and your mortgage loan is owned by Fannie Mae or Freddie Mac. Student loans. Beginning March 13th, borrowers with federally held student loans will have interest rate set to 0 for at least 60 days. And I believe this is actually extended through the end of October. I believe, or at least the middle of October. Or if you were not already in default, you could have suspended your payments for that period as well, or collection actions and wage garnishments were suspended for 60 days. If you were already in default, you should contact the Maryland Department of Labor as 1-877-825-9923. Private student loans do not qualify for these programs. So I'm going to switch over to my expungement PowerPoint. I'll talk to you briefly about expungement laws, and then I'll take questions. All right. I have these cool designs that I didn't know were still here. All right. So why expunge? Well, first of all, what is expungement? So expungement is basically just removing your records from public search or case search, for instance. It's important to keep in mind that if having your record expunged doesn't mean that it entirely goes away from everywhere. Generally, it stays on the federal database, the FBI, for instance. But so it's just important to keep that in mind. However, why would you want to have your record expunged? So, any arrest is a public record, even if you weren't convicted. Arrests and charges will appear on background checks and public court records, and this could impact employment, housing applications, child custody determinations. What's eligible for expungement? So, since we are, again, Maryland attorneys, I'm only focusing on Maryland law. Criminal charges that were obtained in Maryland are eligible for expungement. State charges only. So if you have a federal charge related to the same incident, only the state charges are eligible if they meet the other requirements. Traffic entries where there's a possible incarceration, or excluding DUI and DWIs, those are also expungible. In order to file for expungement, you cannot have a pending criminal case. Being on probation or parole is not considered a pending case. Oops, sorry. All right. So what can be expunged? So if your case has any of these outcomes, they can be expunged. So I'll just go over them quickly. So if you receive what's called Nol pros, that's if the state attorney declined to prosecute your case, or you can have it expunged after 3 years, or if you want to have it done, prior to that, you need to file a general waiver and release. So a general waiver and release is basically something you sign that you are waiving your right to sue the police or the state for, let's say, false arrest, for instance. So because they will destroy their records as well once it's expunged. So that's why you have to sign a general waiver and release. Also, if you are found not guilty or your case was dismissed, it can be expunged after 3 years or at any point prior to that with a general waiver and release. State, that's an indefinite postponement of a case, or that can also be expunged after 3 years of waiting, or at any time if you file a motion for good cause exception and that motion is granted. Probation before judgment can also be expunged 3 years after 3-year waiting period or after the completion of your probation, whichever is longer. Again, at any time you can file to have it expunged with a motion for good cause exception, and if that motion is granted. If you were arrested and you were released without charge, so prior to October 1st, 2007, you had to manually, apply to have that expunged, or now it automatically gets expunged 60 days after your release. Again, that's if you were arrested without charge. Generally, if you are found guilty of a crime, it cannot be expunged, but there are some exceptions, which I'm going to go through, and these are some of them. So, if you are found guilty or not criminally responsible for what the state considers nuisance crimes, for instance, urinating in public, riding a transit without paying a fare, panhandling, and the rest that are listed here, or those can be expunged. If you were found guilty of a crime that is no longer a crime, for instance, possession of marijuana of less than 10 grams, that can be expunged. Or, or if you received an unconditional pardon from the governor, and that's only good for one nonviolent criminal act, that can be expunged. Now, what cannot be expunged? So the general rule is that unspecified felony convictions and unspecified misdemeanor convictions cannot be expunged. Also, there's something called a unit rule. So a unit consists of two or more charges other than minor traffic violations arising from the same incident. If any charges in the unit is not expungible, the entire unit is not expungible. Also, if you are found guilty or received a probation before judgment on a DUI or DWI, that is not expungible. Also, if you receive probation before judgment on any other charge and you had a subsequent conviction within 3 years, that PBJ also becomes not expungible. And if you wanted to check your criminal record, you can go Maryland Case Search, or that's the public record. Also, if you have an old charge that is not showing up on Case Search, you can contact the Criminal Justice Information System or have their address listed. And for a fee of $38, they can give you your complete fingerprint and complete criminal record. I just keep that on the screen for a few seconds. Okay. And I think I said previously that generally, if you're found guilty, all those cases can be expunged, but there's some exceptions, which I covered a few earlier. But in October 2017, Maryland enacted what's called the Justice Reinvestment Act. This meant that expungement became available for those who have been convicted of eligible misdemeanor offenses. And there are over 100 specified misdemeanor offenses that are eligible for expungement. And these include, but are not limited to, second-degree assault, drug possession, prostitution, theft, disorderly conduct. Now, if you have any criminal history, it's important to speak to one of us, because, like I said, this isn't an exhaustive list, so you may have something that is eligible and you just don't know it. Okay. Now, for these misdemeanors, if you were found guilty, in general, there is a 10-year waiting period before you can file for expungement. The exception is if you were convicted of second-degree assault, and second-degree assault that stems from domestic violence. For that, there is a 15-year waiting period. And it's important to keep in mind that the unit rule still applies. So if you get convicted of a felony or an eligible misdemeanor arising from the same incident, then these otherwise expungible misdemeanors will not be expunged. So if any charge in a unit is not expungible, the entire unit is not expungible. Subsequent conviction still applies. So if you were convicted of a misdemeanor and you were waiting for the 10-year period, and at year 9 you got convicted of say murder, which is not expungible, that means that charge, even though you have waited 9 years, that becomes not eligible for expungement either. And then I should add that if the new conviction is eligible for expungement, or basically what happens is that you start counting from that new conviction. So if you were convicted of a misdemeanor and you waited 8 years and then you were convicted of another misdemeanor that is eligible for expungement, so you wait another 10 years from that new conviction. And you can't have any criminal cases when you file for expungement. The waiting period begins at the end of your probation, parole, or supervision period if you probation, parole, mandatory supervision. Also, DUIs and DWS, like I mentioned earlier, cannot be expunged if you are found guilty or receive a PGC. Almost to the end. Expungement procedure. So what happens when we file the expungement is that the state attorney has 30 days to object to the petition. If an expungement of a convicted offense, if it's an expungement of a convicted offense, the victim will also be given 30 days to object to the petition. If no objection is filed within 30 days, the court must enter an order for expungement. If either the state's attorney or victim object, the court must hold a hearing. Once an order for expungement is entered, the applicant agencies will have 60 days to expunge the record. Now, what's the effect of having your convictions expunged? So a record that has been expunged may be opened again, but this can only be open if there's a notice sent out to you and there's a hearing held. Also, the court can only open expunged records upon showing good cause. I don't want to get into all of the details, but for instance, if the state attorney wanted to show maybe, there was some incident that was expunged that will link you to another crime, for instance, that might be considered a good cause. And there are other examples. I'm just thinking of one that may come up. But it's rare. I personally haven't had any instance where someone expunged record was reopened. Expunged records are kept separately for 3 years and then destroyed. A person may not be required to disclose information about expunged records to an employer, educational institution, or government licensing agency. Right. So I know I went by quickly, and if there are any questions, again, this is my information, but I can now take general questions if there are any. Thank you.
Thanks so much, Carwallo. So it looks like we just have a couple questions, and both of them are posted into the chat. So the first one is from Yvette, and she's curious about wills and trusts. So do you work with individuals to set up wills? If so, what are the costs, and when can someone set up an appointment? Also, concerning living trusts, are they considered legal documents if it was only notarized?
Okay, it's been a while since I did estate planning, but Maryland Legal Aid, we have some attorneys who do wills. We do not do trust. We do wills, and when we do wills, those wills are free. So if you're eligible for our services. So what I would say is you can contact us and either from the number I gave you or just our general intake number if you Google Maryland Legal Aid, and one of our wills attorneys will be able to assist you with that. And like I said, if you qualify, all the service will be free. Well, the second question, again, since we don't do trust, I don't want to give advice on that. So I would defer that answer, as I'm not 100% sure on that one.
Okay, no worries at all. And then we have a couple questions from James about expungements. So does the expungement period start from when you start your sentence or once you're released?
So it starts from when you are released. So, but keep in mind, if you were released on probation, it won't start until that probation period has ended.
Okay, and the amount of times that you're able to request an expungement of your record?
You can request as many times as they become eligible. So we've had instances where you might have a client who, say, for instance, has 10 convictions or 10 charges on their record, and 4 of them are eligible for expungement now. So we go ahead and file those 4, and then when the other ones become eligible, we file as they become eligible.
Okay, well, it looks like there's not any other questions from the audience. If there are any folks that are in the Crowdcast or in Facebook, please feel free to send us your questions. For Carwallo, thank you so much, Carwallo, for giving us your time today. The workforce development team at PGCMLS has been working very hard lately to develop their own programming, to develop relationships with outside institutions like yourself. So hopefully in the near future, you'll be seeing more content coming from the workforce development team as far as a dedicated web page on the PGCMLS site. And as always, we're very grateful for Maryland Legal Aid. You all have done a lot lately for our system with our Lawyer in the Library initiative that we've been kind of participating collaboratively with over the last couple of years. Carwallo, have you ever been involved in any of the Lawyer in the Library programs?
Personally, no, but 3 of the attorneys in my unit, that's their main jobs. So I usually do the workforce development sites, but the other attorneys in my unit, they do the Lawyer in the Library.
Okay, great. So what kind I don't know if you're able to answer this question, but what types of help are those folks able to offer with the Lawyer in the Library program?
So generally, we offer help for most civil legal issues. So expungements, like I went over, is something that we cover. Also, there's let me pull something up quickly. All right, so we do consumer rights, we do elder rights, we help with employment issues, family law issues, farm workers' rights, government care, government benefits, healthcare, housing, so landlord-tenant issues, veterans benefits. We also help with child abuse and neglect, and we help with foreclosure. And we also have other attorneys that help with bankruptcy as well. So for most civil legal issues, our attorneys can help. And those of us in the community lawyering unit, if it's a substantial issue, say like bankruptcy that we don't do on a daily basis, we have bankruptcy attorneys and Maryland Legal Aid. So what happens is, once we speak with a client, if it's an issue that we don't handle ourselves, we always pass them on to the appropriate department.
Well, sounds great. Well, you all have been doing so much good work for the community lately, so thank you for that, and continue the great work.
Thank you.
Thank you so much, Carwallo, and thank you everybody for joining us today with PGCMLS and Maryland Legal Aid. We appreciate you. Thank you.
You're welcome. Take care, everyone.